Hello, my name is Jeana Johnson. I'm an advocate for parents dealing with family court and child protection services, also known as CPS. In this video, I will be educating parents whose children have been removed. You will not get this advice from your attorney, whether appointed or retained. Number 1, don't admit to anything. Don't even talk. State that you need representation and you don't fully understand. If you find yourself in court, know this: the court is going to remove your child regardless. Number 2, at the onset of your case, advise CPS to correspond with you via email. Do everything in writing. Number 3, you don't have to advise your attorney, but communicate in writing through email with him or her as well. Number 4, don't sign a case plan. If the caseworker tells you that she will say you're not compliant for not signing, tell the caseworker that she has just intimidated you. I guarantee you that the case plan violates your civil rights. I guarantee you that it does not follow the guidelines, and I guarantee you that if you sign it, you will be agreeing to being exploited and having your children exploited as well. Get a copy and take it home and read it. Read it multiple times. Don't sign it and write a reason on there why you aren't signing it, such as, I believe at this time my civil rights are being violated, undated. If the court happens to ask you what civil rights, tell the court the caseworker used intimidation for coercing you to sign the case plan. Now, this case plan will be filed in court, and CPS will remove or rewrite your reason for not signing. And you're expected to know what's on that case plan. The case plan gets filed and your attorney gets a copy of it. Demand, again, an email and writing to your attorney to provide you with a copy and time to review it. Review the case plan, go directly to where your signature is and see if they have changed the reason you have not signed. If they did, then they have just presented the courts with fraudulent information. This is grounds to dismiss a case and criminal charges of a misdemeanor onto the caseworker. However, it's not enough, but believe me, you can get more as the case moves on. Number 5, start mental health counseling as soon as possible. If you think you're going to get a bad review from the mental health worker in that time of your life, still go, just do not sign a release. Number 6, instruct your attorney in writing that you want to file a motion for the magistrate or judge to court order to have the child receive a clinical mental health assessment within 30 days. In the motion, specifically state, no one at CPS is certified or licensed to make any recommendations without linking the services to which they are responsible for. And that service is an assessment by a licensed mental health worker. Otherwise, this is the critical piece of your case that needs to be completed, and they will prevent it. You have to put some accountability onto the judge to get these services linked, or you will find yourself not getting the services until 6, 7, 8, 9 months later, and that's 6, 7, 8, 9 months of information that could have went to the judge on your behalf. Okay, number 7, if you can't pass a drug test, then don't do it. In time, you can admit to noncompliance on the drug screens by showing honesty about substance abuse. Because right now, you're considered a piece of crap liar. And so later on, when you show some hardcore honesty, that wipes out the piece of crap liar image. I say that to say this. The CPS and the family court system do not serve an agenda for family preservation. They serve an agenda to receive funding through the Health and Human Services via the Social Security Administration title funding. Where does that money come from? It comes from the paychecks of the working folks in this country. Thank you.